The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about who gets to stay in the house during a divorce in Illinois. The easiest way to determine this is by coming to an agreement. The parties can agree who will reside in the family home during the pendency of the divorce, who will find other accommodations, and how those other accommodations will be paid for. This agreement won't necessarily impact who will get the home at the conclusion of the divorce. If the parties can't agree, the status quo will continue and neither party will have the right to kick the other party out unless one of a couple exceptions applies. The first exception is if the home was acquired before the marriage by one of the spouses and the other spouse was never added to the title. So one of the spouses has acquired the home in their own name and it never became marital property because the other spouse was never added to the title, then the spouse that acquired that property before the marriage is likely to be awarded the right to stay in the property during the divorce. They still have to go through the court process by filing a motion for exclusive possession of the family residence in order to do this. They can't just kick the other spouse out. If the spouse who is on title just tries to kick the other spouse out, the police will help the kicked out spouse get back into the home. So you've got to go through the court process through a motion for exclusive possession in order, even if you're the one who's ultimately going to wind up with title to the house and the right to stay there in order to get the other spouse to leave, and if you can't come to an agreement. Another exception is if the mental or physical well-being of either spouse or the children will be jeopardized by both spouses continuing to occupy the residence. In this case, you can also file a motion for exclusive possession. However, courts generally require actual danger as opposed to the normal stress associated with living together during a divorce in order to grant this motion. So it has to be something over and above what you would expect the level of uncomfortable tension between people going through a divorce and living together would be. However, if a spouse is engaging in significant negative, threatening, or harassing behavior toward you, you can, instead of doing a motion for exclusive possession, file a petition for an order of protection, and this will allow them to, the court may allow you to immediately remove that person from the residence. And this is usually the path of least resistance, and you want to do an order of protection in situations where there's overt threatening behavior or harassment going on. And this is usually the easiest way to get the other spouse removed from the house. If you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.